Hello.
So I gave this talk yesterday about this case Stemp. Have you heard of it?
I have.
It's a disaster for landlords and wrong. And I gave this talk and everyone was like outraged that this could be the law, it's completely wrong, what a landlord's supposed to do. Awful.
Yeah, and I actually read it. I mean, I didn't see it when it came out originally about 18 months ago. For some reason it went under the radar, but I saw it recently.
Well, it's an Upper Tribunal decision.
And I thought it was quite a good case. I thought it was quite a good decision, actually.
Have you read it?
Yeah, he's on a Judge Huskinson.
Yeah.
Very bold, as Sir Humphrey Appleby used to say. Very bold decision. But
yeah, so what he says is, it's in the tribunal and it's all about costs, but actually the point is it's all about forfeiture and waiver of the right to forfeiture.
Yeah.
And a landlord is now seriously at risk of waiving just by breathing near the tenant. Anything the landlord does
That's not true.
in a very long period, the landlord's in danger.
Okay, what the case says is that when a landlord is waiting for a decision of the tribunal,
Not just waiting. Before they make the application, whilst it's pending, whilst the tribunal's sitting around thinking about what they're going to do.
Yeah, okay, let me just finish my sentence if I may.
I don't think you understand it.
I think I do. What it says is that between the breach and when the landlord gets the order allowing it to go forward under section 81 of the Housing Act 1996 to forfeit, in that period...
It's not quite that period, by the way. It's not from the breach. It's from when the right to forfeit arises under the lease.
Right.
It's usually 21 days after that.
Right, from... If you let me finish...
Well, you're getting it wrong.
From the date that the landlord has the right to forfeit, it can waive that right to forfeit. And it doesn't matter if it's not able, because of section 81, to actually affect the forfeiture. It can still be held to have waived that right. Just because it's not allowed to do something doesn't mean it hasn't made an election between two inconsistent courses of action, namely recognising the tenancy or not recognising the tenancy. That's all it says.
How can you choose not to do something which is impossible for you to do? That's not a choice, because it was never open to you to do something. If you think about it practically, and this is where the landlord gets really destroyed in this case, because how is a landlord supposed to continue managing the building, dealing with its repair obligations, consulting as it has to under section 20, addressing any disrepair obligations of the tenant during this long period, many months, when it needs to be very careful about waiving?
Yeah, but that's like attacking VAR when really you should be attacking the offside rule, isn't it? Really, you should that's not a helpful analogy to me. Right. Really, you should be saying that the law of waiver is an anachronism. But the result is actually that landlords, I suppose, are in a much more vulnerable position if they're waiting to go through the statutory hoops in relation to forfeiture, and of course need the money to carry on running the building from the service charge income stream.
Yeah, but there will come a point where the landlords run out of money, and especially if it's a tenant-owned landlord company, which often is, landlords run out, they don't have any money.
Yeah.
And do you know what the tenant's answer to that was?
No, what?
Borrow money. They'll just borrow money, which I didn't think the landlord thought was a good option. It was
not you, the car.
It was going to be appealed, but it's settled. But I'm telling you, it would have been successfully appealed.
Well, we'll never know now, will we? So waiver's back in fashion, isn't it?
Back in fashion.
Back in fashion. Waiver's back in fashion.